Should a psychiatrist's predictions about a defendant's future behavior be admissible to determine whether the defendant should be sentenced to death? Does it matter whether the psychiatrist's predictions are reliable? The United States Supreme Court explored these questions in Barefoot v. Estelle. Thomas Barefoot had an extensive criminal history that included crimes ranging from drug use to assault to armed robbery. Barefoot was also wanted on charges of sexual assault of a young child. Barefoot had vowed to kill the next officer who tried to arrest him. Police officer Carl Levine approached Barefoot at a vacant house, attempting to question Barefoot about a recent arson fire. Barefoot shot Levine, killing him. Barefoot was convicted of Levine's murder. At the sentencing hearing, the prosecution presented evidence of Barefoot's criminal history, his reputation, and testimony from two psychiatrists. Neither psychiatrist had spoken with Barefoot. In response to hypothetical questions from the prosecution, both psychiatrists testified that Barefoot would probably commit further acts of violence and that he represented a continuing threat to society. The jury determined that Barefoot had deliberately killed Levine and would likely commit future violent acts and be a continuing threat to society. Based on these determinations, Barefoot was sentenced to death. Barefoot appealed the sentence, arguing that psychiatrists, as a group, couldn't reliably predict an individual's future dangerousness. Barefoot claimed that these unreliable predictions could cause erroneous or arbitrary sentences, which violated both the Eighth Amendment's prohibition on arbitrary punishments and the 14th Amendment's due process requirements. Barefoot also argued that even if psychiatric predictions were allowed, they shouldn't be based solely on hypothetical questions about someone the psychiatrists hadn't evaluated. Finally, Barefoot claimed that even if this testimony were theoretically permissible, the particular testimony in his case had been so unreliable that it was unconstitutional. The Texas state courts denied Barefoot's direct appeal, and the United States Supreme Court declined to review it. Barefoot then filed two habeas corpus petitions in state court, collaterally attacking his sentence using the same arguments. Both petitions were denied. At the same time, Barefoot filed a similar habeas corpus petition in federal district court. The district court denied the petition on its merits, but issued a certificate allowing Barefoot to appeal to the Fifth Circuit. The Fifth Circuit denied Barefoot's petition. The United States Supreme Court granted cert to review the habeas petition. The American Psychiatric Association submitted an amicus brief contending that psychiatric predictions of dangerousness were wrong 2 out of 3 times and shouldn't be used as sentencing evidence.